Welcome to this course on understanding gender in law. Today we will be discussing the role of law in the society. The law plays very important role in a society which has different dimensions. So today we will discuss upon the concept of sociology of law. We will discuss distinction between sociology of law and the sociological jurisprudence. Because generally when we talk about sociology of law or sociological jurisprudence, how the jurists who belong to the sociological school of thought, how they interpret law. Relations of society and law needs to be understood within the larger context, social science approaches and perspectives based on humanities. Now, interdisciplinary understanding is deployed by the scholars to map the complex linkage between society and legal transitions. Sociology of law produces important readings related to the connection between societal changes and emergence of legal cultures. Before we delve into the specificities of sociology of law, it is important to know the historical understanding of sociology of law, its diverse interpretations, and its background related to social and political churning in relation to the production of legal knowledge. Extending from the concept of the primary function of law, which is social integration, law can be stimulated relative to other social institutions such as economy, politics, and culture. Now, sociology of law, let us look into the theoretical concepts. Now, sociology of law can be considered as an important subdiscipline within the grand intellectual culture of hegemonic sociology. There are different interpretations regarding the definitional understanding of the subfield sociology of law. Now, legal sociology for Javier Trevino is an academic specialty within the general discipline of sociology that attempts to explain the relationship between law and society. The social organization of legal institution, order or system, the social interactions of all who come in contact with the legal institution and its representatives like police, lawyers, judges and legislatures, and the meaning that people give to their reality. So, sociology of law produces the context-based and empirically rich accounts of law. Sociologists who belong to the subfield of sociology of law, they read law as a social construct and attempted to delineate the nuanced connection between society and law. Historically, the sociology of law is considered as the offshoot of the sociological movement within the discipline law. In the background of post-Second World War in United States, law therefore is read as a social phenomenon. Sociologists who study law seeks to determine how the intersection between society and law get reflected in the political and social transformation. There are different opinions related to connections and conceptual departures related to sociology and law. Broadly, both sociology and law reflect on the larger field that determine individual, societal expectations, communities and law. At the same time, it is critiqued that sociology of law should not be just confined to theoretical realm in the field of dominant sociology. It should be simplistic premise that articulates law as a knowledge emerged in response to transforming social and political environment. Now, if we look into the wordings of George Gurevich, a Russian-born scholar, he says that sociology of law is that part of the society or that part of a sociology of human spirit which studies the full social reality of law, beginning with its tangible and external observation expressions in effective behaviors like it would be customary practices and traditions or behavior innovations, and in the material basis. Similarly, other scholars like Brett, he pointed out that sociology of law deals with external symbols or legal procedures and internal meanings. Law therefore is theorized as a social system. Sociologists who are specialized in the field of sociology of law explore social character of law. Social nature of law is considered as one of the most important aspects. Sociologists thus examine the various facets that determine legitimacy, legislation, judiciary, culture of legal profession, etc. Sociologists considered sociology of law as a means to overcome the inherent problems within various laws that act as hindrance to dynamic operation of various societal aspects. Social theoretical realms on society and law. Now, there are different readings, if we go into the theoretical realms on the society and law and their functioning. So, there are different readings which related to the emergence and transformation of law in sociology in particular and social theory in general. Modern and postmodern readings with the sociology of law engage with the various theoretical and empirical discourse in the field of social sciences. The sociologies of Max Weber and Emile Durkheim are indisputably foundational to the modern sociology, including the sociology of law. Max Weber analyzed the limited facet of juridical view that has problems in assessing the impact of law over the society. One of the central concerns of sociology of law is that whether it can pave way to social engineering through transiting the heights created by law in books and law in action. It attempts to map when a norm is transferred into law, whether it will be recognized by the political institutions or not, and whether the state engages with it in a systematic manner or not. Now, Max Weber, he says when we speak of law, legal order and legal profession, the close attentions must be paid to the distinction between the legal and the sociological points of view. Now, Max Weber's theory of rationalization uses the model of bureaucracy to symbolize the constant shifting ways of our society. Rationalization is the process of replacing rationally consistent rules for conventional or rather illogical rules within society. According to Weber, bureaucracy is the fundamental model of rational rule. Now, Emile Durkheim, he also analyzed law in his sociological study of the moral foundations of the division of labor, and it is well known among the sociologists. To empirically examine the transformation of society from mechanical to organic type, Durkheim turned to the evolution of law as an indicator of changing moral foundations of society. Durkheim's central concern is to show that modern society is characterized by solidarity that preserves the individualism, who remains the valuable today. The value of this approach is not exhausted with reference to the empirical adequacy of Durkheim's thesis on law, such as concerning the evolution from repressive to the restitutive law. For in addition to sketching an empirical model of law in society, Durkheim's sociology of law also encompasses an innovative approach to the study of law. Law, for Karl Marx, is very much integral to the bourgeois state. Ruling classes are analyzed central in the protection of legal concepts. But Lon Fuller analyzed that by speaking of law and society, we may forget that law is itself a part of society. So, law is an integral part of a society and it influences the society. Social theory and law, how it is integrated. The social theory seeks to explain systematically the structure and organization of society and the general condition of social order or stability of a social change. Since law as a system of ideas can also be thought of as purporting to specify, reflect and systemize the fundamental normative structures of society, it has appeared as both a focus of interest for social theory and in some sense a source of competition with social theory in explaining the character of social existence. The relation of legal thought to social theory represents a confrontation between competing general modes of understanding the social relationships and the conditions of social order. In one sense, this confrontation is old as philosophy itself, but as an element in modern philosophical consciousness, it represents a gradual working out in Western thought over the past 2 centuries of the implication of various scientific modes of interpreting social experiences, all in one way or another the legacy of Enlightenment ideas. Now, social theory of law departs from the foundational understanding of sociology in particular and social sciences in general. The social theoretical perspectives delineates legal doctrine. It can be said that social theory has its root in legal theory, and the agendas of classical social theories are tied up with jurisprudence. The legal doctrine refers to law, procedures, principles, normative conceptual stakes, and values. A doctrine becomes legal when it is created, interpreted, or enforced in certain socially established ways through their cognized procedures and agencies. Now, it is seen that contemporary social theory is struggling with many issues, as but now with the differentiation of disciplines, each field is more likely to go to its alone. Now, if legal theorists and social theorists followed the development of each other's discipline more closely, we might avoid some blind alleys that the other discipline has already discovered, and we might learn something in justification that would otherwise go unnoticed. Now, in context of globalization, globalization has drastically changed the enclosures that determine law and global local society. Globalization is pivotal in erasing the various boundaries that differentiate various states across the globe. However, scholars like Walden Bellow, he analyzed the changing global scenario in the context of deglobalization. The Western legal frameworks are hegemonic, and therefore non-Western legal approaches have to be understood in different ways. Culture of the law needs to be studied as well. Societal and political context of legal development is central to the understanding of contestants between the national and global legal development. Now we look into neoliberalism, and law. Now, social theorists, they have studied how neoliberal political institutions in the capitalist era regulate the upsurge of social movements that protest against the repressive neoliberal form of capital. Now, what is neoliberalism? Now, neoliberalism, we can say, it refers to the revival of doctrines of classical economic liberalism, also called laissez-faire, in politics, ideas, and law. In the context of particular kind of particular and legal conflict, both widespread and long-standing, neoliberalism may refer to the set of recurring claims which is made by the policymakers, advocates, scholars in the ongoing contest between the imperatives of market economies and non-market values grounded in the requirement of democratic legitimacy. Though neither the market nor democratic politics is given a domain, a natural kind, but as an ideal type, they represent competing and potentially opposed principles of social ordering. Law's relevance has been seen as one of the instrumentalization of neoliberal policy through law. Honor Brabergen, in his book Neoliberal Legality, Understanding the Role of Law in the New Liberal Project, he has argued that first law takes a specific shape in the neoliberal period that is consistent with, but also more specific than the liberal capitalist form. Secondly, certain aspects of law have enabled it to play a crucial role in conceiving, constructing, and cohering neoliberalism in a way that other social institutions, structures, or sets of norms could not. Thirdly, neoliberalism should be understood as a juridical project as well as a political and economic project. Fourthly, the relationship between law and neoliberalism is not automatic, but rather embodies contradictions and vulnerabilities that could be used to leverage social change. So far we have discussed about sociology of law. Now, what is sociological jurisprudence? The sociological approach considered law as a social fact or a reality which can shape, mold, and change the society to subserve its need, expectations, and goals through laws. It is concerned more with the working of law rather than the nature of law. Among the foremost writers who made an attempt to apply scientific methods to social phenomenon was Auguste Comte. He is known as the father of sociology as a science. He laid stress upon empirical methods such as observations and experiment for the study of society. It is the task of sociology to provide methods, tools, and a basis for purposeful and realistic appraisal of social phenomena which interact in society. It is useful to dilate upon the contribution made by the important jurists towards the growth and development of sociological school of jurisprudence. They regarded law as a body of authoritative guides to decision and of the judicial and administrative process rather than the abstract content of authoritative precepts. So they emphasized on functional aspect of legal institutions, doctrines and legal precepts which are regarded as means to satisfy greatest good of the greatest number. The proponents of this school, they reject the classical positivist notion that there can be a value-free evaluation of law. According to this school, the law should be viewed having inherent moral content espousing society's value. Law is not an absolute and static body of rules in themselves, but are relative to time, place and society. So we have seen, we have also referred to the sociology of law and what is the thought and what we can curl out from the sociological jurisprudence about the law. Now, is there any difference between sociology of law and sociological jurisprudence? We can say it is difficult to draw a very hard and fast line of demarcation between the two because of their identical subject matter, but they do differ in respect of their theme and approach to law. Now, sociology of law is considered as descriptive study of law and legal institutions of a given society that seeks to provide explanations for the social context of law and how this affects the application of law using scientifically derived evidence. According to the view of Rusco-Pond and Hall, sociology of law is mainly a descriptive study of law, a theoretical science. It treats law as just one of the several aspects of society. So, sociology of law is just a branch of sociology and the society is the main theme of sociology. So, sociology of law is a basically descriptive study of law and legal institutions in a given society. Sociological jurisprudence, on the other hand, we can say it is concerned with analysis and the interpretation of the part played by law and its institutions in affecting certain observable forms of social conduct, relations and behavior. It goes beyond the sociology of law and departs for socio-legal studies in the sense that it combines the scientific method of inquiry and philosophical and conceptual approach towards understanding the meaning and purpose of law and the legal order. Sociological jurisprudence has also been called as functional jurisprudence or jurisprudence of interest or jurisprudence of social engineering. So, we have discussed what is the approach of sociology of law, what are the theoretical realms of law and how the sociological jurisprudence approach has considered law in the society, which concerns with the analysis and interpretation of the law and its institution in affecting certain observable forms of social conduct, relations and behavior. But we can conclude in the words of Dr. Timashev, the sociology of law exists as distinct science, whereas sociological jurisprudence is merely a branch of science and jurisprudence. However, both consider society as the matrix of their common interest. So, we have in this session we have discussed about sociology of law, the distinction between sociology of law and sociological jurisprudence, how they conceive law, what are their approaches towards the law and how the law play a role in society. We will continue with the other sessions where we will be discussing about the impact of legal transformations in India, and we will also discuss how what are the social dimensions of law, the law and culture, or law and politics, and law and economy in other sessions. Thank you.